All right, we're going to get started. Welcome, everybody. Hi, my name is Zach. I'm the director of the Graduate Student Legal Aid Office here at the University of Maryland. And we are here to help with a lot of different topics of your legal needs, whether it's a landlord-tenant issue, whether it's a speeding ticket, whether it's something more serious like a divorce or employment contract. We're here to help provide advice and counsel you on those issues. But one of the things that, as you know, we also do is we provide weekly workshops on a number of different legal or tangentially legal topics. And one of our most popular of the year is this one, which is how can I get permanent resident status in the US? We are lucky to have Patricia Minikin, who is a wealth of knowledge in the field of immigration law. She's been practicing immigration law for more than 30 years. She's the founder of her own law firm, Minikin Law, which is based out of Greenbelt, very close to our College Park campus here. She's also taught immigration law at the Penn State University Law School, as well as the University of Maryland University College. And we've been lucky enough to have her volunteer and give these workshops for our graduate students for as long as I've been here, which is more than 5 years now. And so I know that she's been a few years longer than that. And so we're lucky to have her time today. And so just a few ground rules or expectations. This tends to be a really popular workshop where we might have 100 or 150 people pop on. And so we are using the Q&A feature in Zoom where you can submit your question. You can also upvote other questions if somebody else has your question and you want to get it sort of to the top of the list. For the most part, we're going to be answering all the questions at the end. We're going to leave lots of time for those questions. And so a lot of the information may be answered on the next slides. We're not going to interrupt Patricia throughout, but feel free to submit all of those questions. We also have the list of pre-submitted questions that you sent us ahead of time that we're going to try to get to as well if we can. But we're really happy to have you here. And we're really happy to have Patricia. And with that, I will hand it off to Patricia to begin the presentation.
Thank you, Zach. Good afternoon. Today, I'll be presenting on how you can obtain permanent resident status in the US. I will not be talking about non-immigrant visas, so just so that people understand. I know that some of the questions sent in advance speak a little bit about some non-immigrant visas, and during the Q&A, I will get to those questions. All right. So today we'll be talking about pathways to get a green card. There are several pathways. There are the humanitarian programs, and then you have some special programs for specific groups. Then we have family sponsorship, which may be a little more well-known, employer sponsorship, and self-sponsorship, ways that you as a student can apply for a green card without the need for a job offer. First, we'll talk about the humanitarian programs. The first program I'd like to share is asylum. An asylum application has to be filed within 1 year of entry or within 1 year of change
এখন
circumstances
জানতাম না এটা শুনতে গ্রিন কার্ড এটা এখন বলবো
that okay, or within 1 year of changed circumstances that would lead you to filing for asylum. You have to base the asylum application on a fear of persecution due to your religion, particular social group, race, political opinion, or nationality. Particular social group can be any group that you belong to that has characteristics that are immutable, and groups that are seen as discrete groups by the society that you come from. After, I'm sorry. Okay. If you're granted asylum, you can adjust your status to that of a lawful permanent resident of the US after 1 year. You are given credit for 1 year. So when you get your green card, you only have 4 more years before you can file for citizenship. Some of the conditions for someone granted asylum include the fact that they cannot return to their home country until they are a US citizen. You can have other applications pending simultaneously. It takes an average of 10 years to get an interview on an asylum application. And during those 10 years, if say you get married, your spouse can file for you, or if you have an employer willing to sponsor you, you can have that employment-based application filed at the same time. A second visa that allows you to get a green card is a T visa. This is for persons who are victims of trafficking. And you get, the first step is that you'll be issued a temporary non-immigrant visa for 4 years, but then you can file to become a permanent resident after 3 years or after the case is closed. And T visa applicants have to be victims of sex or labor trafficking. Sex trafficking is either it is where you're induced or forced to engage in a commercial sex act by force, fraud, or coercion of a minor. You can also be an adult, but minors, anytime a minor is forced to engage in a commercial sex act, that is sex trafficking. Labor trafficking, on the other hand, is where you've been forced, tricked, or coerced into providing labor or services, and you weren't paid for it. So it amounts to involuntary servitude, peonage, debt bondage, or slavery. You need to assist law enforcement in the investigation or prosecution of these crimes. And like I said, you can then adjust status after the case is over or after 3 years of being on a T non-immigrant visa. Another program is the U visa. This visa is specifically for victims of specified criminal activities. These are usually crimes against the person, like rape, murder, domestic violence, blackmail, stalking, witness tampering, or related crimes. As an applicant, you must suffer mental or physical harm. You must be helpful in the investigation or the prosecution of the crime. The crime has to have occurred in the US. You also get a visa for 4 years, and you can adjust to permanent resident status after 3. Now, the only caveat to this visa is that law enforcement must certify that you've assisted in the investigation or prosecution of the eligible crime. So if you say file based on domestic violence, the police must certify domestic violence and not say assault. And the police must be willing to certify. There are police departments that are not willing to certify. So it's important to know whether the police will certify or the law enforcement or court will certify that you have been helpful in the investigation and prosecution. Another humanitarian pathway to getting a green card or permanent resident status is VAWA. It's the Violence Against Women's Act. It applies to male despite the name. And you apply if you've been a victim of battery or extreme cruelty committed by a US citizen or permanent resident who can be a spouse, former spouse, parent, or child. So you apply for the relief, and you can apply at the same time for a green card if one is available. It's all given to you on the basis of being abused. And if you find yourself in removal proceedings or deportation proceedings, you can file for, it's called cancellation of removal, but it's based on only having been in the US for 3 years compared to 10 years, which is what others who are not filing based on abuse have to prove. So you're able to file for this relief, whether you're filing affirmatively or whether you're filing defensively. With humanitarian programs, it's a good pathway to a green card because there are certain waivers available that are not available for others, say those filing for a green card through family. You have waivers that will waive entry without inspection, entry without a visa, will waive your unlawful presence if you enter without a visa and you remain here for more than a year, or more than 6 months, it'll waive that unlawful presence. Or if you enter with a visa and then later violate that visa status, or you no longer qualify for that visa, you would accrue unlawful presence, and the humanitarian programs will waive that. It will also waive convictions. It's very generous as far as understanding why someone committed a crime, and very generous in waiving those convictions because certain convictions prevent a person from obtaining a green card. So the humanitarian programs end up being a very helpful pathway to a green card for an undocumented person or a documented person who is someone who entered initially without status and now could get status through one of these humanitarian programs. There's another green card program available. It's for persons who are less than 21 years old. It's a special immigrant juvenile visa. It's based on the person having been abused, neglected, or abandoned by their parents. And the way to obtain this benefit is to apply in state court for an order. Usually it's a guardianship order, so you need someone who will petition for you to be your guardian until you turn 21 years old. Some states, though, restrict this to you being no more than 18. But in this area, Maryland, Virginia, and DC, the age is 21 years of age. So you could, be a college student and apply for this. So you obtain a state court order finding that you have experienced abuse, neglect, or abandonment. And once you have that order, you then file a petition for special immigrant juvenile status with USCIS. Once that petition is granted and when a visa is available, there's right now a 3-year wait. When a visa is available, you can apply to adjust your status to that of a lawful permanent resident and obtain a green card. Now, even though it takes 3 years to obtain for a visa to be available in order to file for the green card, after you file for the special immigrant juvenile status, and it is granted, USCIS can grant you something called deferred action. Now, with deferred action, you're able to file for an EAD or work permit. So this, again, is a good path for someone who may have come on a student visa, but also for someone who entered the US without a visa, who is currently undocumented, or who is documented because they entered the US without any visas or without any valid status. Our next path to a green card is through family. Now, there are only certain relatives who can sponsor you. And depending on the relative and their immigration status, you could be classified as an immediate relative, or you could fall into the preference category. Immediate relatives do not wait for a visa, but preference categories wait for a visa because there are a limited number of visas issued each year for preference categories. So usually relatives of a US citizens, except brothers and sisters and except children over 21, are immediate relatives. They do not need to wait. So spouses of US citizens, parents of US citizens, children under 21 of US citizens. If you entered with a visa, but that visa has since expired, there is no penalty. You can still go ahead and apply to adjust your status to that of a permanent resident. And if you're a spouse of a US citizen, there's no penalty if you adjust your status within 90 days of entry into the US. Now, the preference categories where you have to wait for a visa are the adult child of a US citizen, that is someone over 21 years of age, spouse and unmarried children under 21 of permanent residents, unmarried children of permanent residents who are over 21, brothers and sisters of US citizens, and married children of US citizens. All those must wait for a visa. The process of getting an immigrant visa through family is that you file, your sponsor or the relative who is the permanent resident or US citizen files a petition for you. If, for example, this is a spouse, you will need to show supporting evidence that you are married, that you have a joint life together. If it's a parent, you have to show that you are the child, usually a birth certificate, and your parent has to show proof of their immigration status, that is lawful permanent resident or a US citizen. The person receiving the green card will need to undergo a criminal background check. Like I stated earlier, certain convictions will prevent you from getting a green card. And then once USCIS receives the documentation, you may or may not be scheduled for an interview. And whether you can file for the green card at the same time that the relative sponsoring you files the relative petition will depend on whether a visa is available. People who fall in the immediate relative category can file right away because there's never a wait. Now, there are some things to keep in mind when you file through family. Is the first is that a lack of supporting evidence will lead to heightened scrutiny. There's no requirement that a husband and wife live together before they're married. But once you're married, you need to prove that you have the intention of a shared life together, meaning you should be living together or have a very good explanation for why you would marry and then not live with your spouse. It is possible if you send in enough documentation to prove the bona fides of the claimed relationship, you will receive the green card without an interview. So it's important and beneficial to have enough evidence to prove the relationship and to prove evidence for married petitions or petitions from persons who are married. Send in enough evidence to prove that you have a bona fide marriage and you intend to live together. Now, in family petitions, you must include an affidavit of support from the sponsor unless the person, the beneficiary, the person receiving the green card, has acquired 10 years of work in the US and paid in 40 quarters, 4 quarters a year, paid into 40 quarters of Social Security. If not, the person petitioning must file an affidavit of support and must meet the specified income requirements. It differs with the family size and it differs with the amount of persons the petitioner has filed for previously to get an immigrant visa. So you need to look up that information and make sure the petitioner meets the income requirements. If the marriage that gives the beneficiary a green card is less than 2 years old, at the time the beneficiary obtains that green card, the beneficiary will get a green card valid for 2 years and will obtain conditional lawful permanent resident status. 90 days before the second anniversary of the person's permanent residence and 90 days before their card expires, which will coincide and be the same date, that person must file to remove the conditions on their green card and will need to show that they have continued to maintain a bona fide marriage and send in proof of that. So when sending in proof to remove conditions on one's permanent resident status, you want to send in things like jointly filed tax return, joint leases, things that you have acquired jointly during the 2 years of permanent resident status. Divorce has an effect on your conditional lawful permanent resident status in that you usually have to file a joint petition to remove the conditions, but if you're divorced or separated, you won't be able to. So you will need to file for a waiver. And there are only certain types of waivers. There's the waiver where you're battered or have been subjected to extreme cruelty. There's a waiver where you would face extreme hardship if it's not granted. And then there's a waiver where you show that you entered the marriage in good faith, but it's ended through no fault of yours. And if you can prove the basis, you will be allowed to remove the conditions on your green card without the need to have your spouse join you in that application. For persons who would be petitioning and filing an affidavit of support as a petitioner of a family-based visa, keep in mind that divorce does not end your obligation under the affidavit of support. That obligation is that you will support the person receiving the green card until they become a citizen or until they die, or for 10 years until they've earned the 40 Social Security quarters, because it's 4 quarters per year. Now, knowing that marriage to a U.S. citizen is a quick way to get a green card, USCIS focuses a lot on screening out fraudulent applications. If USCIS determines that they have enough proof that the application is fraudulent and there's no bona fide marriage, you can never get a green card. It does not matter whether it is 20 years later or 10 years later, or whether the new spouse and you can prove that you're in a bona fide relationship. You will never be able to get a green card. It's a permanent bar. Turning to the next pathway to a green card would be employment-based. Now, the traditional way is through employer sponsorship. And many students get job offers from employers who are willing to file for them. The main consideration here is which category. Whether the student after graduation qualifies as an extraordinary ability person or will be sponsored as someone with an advanced degree or sponsored as someone with exceptional ability. For those who do not have graduate degrees, they can be sponsored with their bachelor's, their associates, or no degree under the EB3 category. And special immigrants or religious-based immigrants would be EB4. The special immigrant juvenile status that I mentioned earlier is considered an EB4 visa. Now, each category has a different eligibility requirement. So if you're approved in one category, for example, an EB2 advanced degree, you cannot just switch to, say, for example, an EB1 extraordinary ability, because the evidence you would submit to prove that you're an EB2 advanced degree would not suffice for an EB1 extraordinary ability category. So you must qualify for each visa category, and you must qualify on the day you apply, which makes conversion at a later time difficult and impossible unless you meet all the qualifications for the visa category you'd like to upgrade to. And so you cannot just easily switch. So the first preference, the EB1, they're considered priority workers. And these are persons with extraordinary ability in the sciences, arts, education, business, or athletics. It can be, you can also be an outstanding professor or researcher, or you could be a multinational manager or executive. The second preference is the EB2, which includes members of the professions holding advanced degrees. And in this category of the EB2, you're able to self-sponsor without a job offer if you apply for a national interest waiver, which we'll talk about a little bit further in this presentation. EB2 second preference also includes persons of exceptional ability, contrasted with the EB1 extraordinary ability. With the extraordinary ability category, you have to prove that you meet 3 out of 10 qualifications. With the exceptional ability, you have to prove that you meet out of 6. So with the EB2, perm is required, but there is a shorter process for those with exceptional ability in the arts and sciences. You apply for labor certification, but directly to USCIS, not to the Department of Labor. The third preference, the EB3, this includes skilled workers, meaning persons without a degree or only with an associate degree. Also professionals who may have a bachelor's degree, other workers who have no degrees. And this is, you apply for this by labor certification through PERM and through the Department of Labor, not USCIS. The employment base requires labor certification that I just mentioned. It's also called PERM when you're going through the Department of Labor. It is required for the EB2 job offer in the EB3 category, meaning the EB2 when you have a job offer, you're not self-sponsoring. The first step is for the employer to complete a labor certification application that is filed with the Department of Labor. The employer must advertise the job in different mediums to show that they've engaged in a meaningful recruitment process. And then before filing the application, must compile a report on the results of that recruitment process. If the Department of Labor feels that the employer has not engaged in a meaningful process, the Department of Labor can instruct the employer to recruit a second time, to engage in recruitment a second time, and the Department of Labor would then supervise that recruitment to make sure that US workers are being targeted and are able to respond to the job offer. There are employment-based immigrant visas where no labor certification is required, as I've alluded to. There are some occupations that are considered to be on Schedule A. Schedule A is a list of occupations that have been determined to be in short supply in the US. And right now, those are physical therapists and professional nurses. So group number 2, which is on the Schedule A, is for immigrants of exceptional ability in the sciences and arts. And these include college and university teachers and immigrants of exceptional ability in the performing arts. Also, you do not need labor certification for an EB1 extraordinary ability person or outstanding professors and researchers or certain multinational manager or executives who are transferring in from their company who has a branch overseas and also a branch in the US. There are some benefits to the labor certification through the Department of Labor, even though it takes longer. If your application is pending for 365 days through the labor certification perm process, you can renew your H-1B beyond year 6 if an immigrant visa is not yet available. And this comes in very handy for persons who are from India or China or any other country that is backlogged and has a multi-year, more than 6-year wait for an immigrant visa. Also, if you are on an H-1B and you have a spouse who's on an H-4 visa, that spouse can obtain work authorization if the labor certification has been pending for more than 365 days, or an employer petition for you as an immigrant worker has been approved. The employment-based immigrant visa categories, which require labor certification, there's a process. Once the petition has been filed by the employer and the labor certification has been granted, the employer now files a petition for the employee with USCIS. The focus at this point is the ability to pay. When you're recruiting for labor certification, the focus of the Department of Labor is recruitment, whether there's been a meaningful recruitment process. When the employer files with USCIS, the focus is on the employer's ability to pay. And when that process or that petition is approved, the employee can apply for lawful permanent resident status when a visa is available. So if a visa is available at the time the employer files, the employer files their petition and the employee can file to adjust their status to that of a lawful permanent resident. If a visa is not available, the employee will file later when a visa becomes available. And employees find out about visa availability from the Visa Bulletin, which is a publication that the Department of State publishes every month, letting you know what visas they're giving out for the various dates that people file. Now, self-sponsored immigrant visas are available for the EB1 category. The person must be seeking to enter the US to continue work in the area that they possess the extraordinary ability, and their entry into the US will substantially benefit the country in the future. You have to provide evidence that you meet 3 out of 10 criteria. Prizes and awards, memberships in associations that require outstanding achievements, meaning they solicit you, you don't just pay a membership fee. Publications in professional trade journals, serving as a judge of the work of others, significant contributions to the field that you possess the extraordinary ability in. So examples of prizes and awards would be well-known national institutions or professional associations, doctoral dissertation awards for presentations at national or internationally recognized conferences. So the publications would be in professional of trade journals, peer-reviewed publications. Judging the works of others would be where you're completing peer review for a scholarly journal by their request. You're acting as a peer reviewer for abstracts or papers submitted for scholarly conferences. You serve as a member of a PhD dissertation committee, or you're a peer reviewer for a government research funding program. Significant contribution to the field. An example would be published material about you, some project that you're doing, testimonials or affidavits from persons who have collaborated or worked with you. Citations to your work can be significant contributions. With citations, quality will matter. If you're just included or your article is included in a string site, or whether your article is included to assert that this is a truth in this particular field of research. If you've obtained patents or you have licenses in your field, that could be significant contributions. The next self-sponsored immigrant visa or green card pathway is through the national interest waiver. So to demonstrate eligibility, you have to first prove you have an advanced degree. This can be a master's or it can be a PhD. A STEM PhD is a great advantage when you're filing for a national interest waiver, because you have to prove three things in order to be granted a national interest waiver. The first is that your proposed endeavor has both substantial merit and is of national importance. Meaning substantial merit means the US needs whatever it is that you're proposing. And national importance means it will benefit the entire United States. That's why if you propose to teach, it will not qualify for a national interest waiver because teaching is limited to the university you're teaching at. The next thing you have to show is that you're well positioned to advance this proposed endeavors. And the third is that it would be beneficial to the US to waive the requirement of a job offer and thus the labor certification process. Now, if you're a STEM PhD, you are presumed to have a proposed endeavor that has substantial merit and national importance, and you're presumed to be well positioned to advance your proposed endeavor. This is why STEM PhDs have an advantage in this process, because the only thing they would need to prove is that it's beneficial to the United States to waive the job offer requirement and the labor certification process. Whereas someone with only a master's, even if it's a STEM master's, would have to prove all three requirements. Now, the national interest waiver, it means you do not need an employer petition, you do not need a job offer, you will not need to go through labor certification or the PERM process. If you have an interested government agency that maybe you've collaborated with, getting letters from that agency is very, very helpful, because it helps demonstrate that your proposed endeavor is of national importance, in that you have a federal government agency or a state government agency supporting your application. You usually want to have letters in support. It could be from professors you've worked with, labs you've worked within. It can be an entrepreneurial project as well, as long as you're very detailed as to how this project would benefit the United States substantially, nationally, and that you're well positioned to advance this entrepreneurial project. I gave a Zoom presentation on the national interest waiver, and you have the link there and the URL to look it up. This presentation will be available after through the legal aid office, so you'll have access to the slides. Now, there is another pathway to a green card through self-sponsorship, and that is the investment or EB-5 visa. You need to invest $1 million into an investment in the US. The full million has to be at risk. If you're investing in an area of low employment or high unemployment, the investment can be $500,000. Those areas, though, you would have to look up because USCIS maintains that information. Now, as part of the investment visa, you have to demonstrate that you've created 10 jobs for US workers. And initially, you get a green card that's valid for 2 years. At the 2-year anniversary or 90 days before the 2-year anniversary, you have to show that you have maintained 10 jobs for US workers for at least 2 years in order to get the conditions removed from your EB-5 green card. So that also has a conditional residency similar to the family-based category where the marriage is less than 2 years old. Now, there are considerations when you're applying for a green card. With the family base, you want to file when you can prove you have a joint life together and you have proof that your marriage is bona fide, meaning you have joint bank accounts, joint assets together, joint liabilities. If you just got married, you haven't opened a bank account, open a bank account, have some activity, maybe 1, 2, 3 months, and then file. It makes it much easier to get through the process if you have the requisite proof. When you're self-sponsoring, understand that US law allows you to pursue more than one pathway to a green card. So you could apply for an employer-sponsored and a self-sponsored green card, or you could apply for asylum and a self-sponsored green card. When you file for a self-sponsored green card, make sure you've met all the requirements. So if you want to apply as a PhD, a STEM PhD, wait until you get the PhD. Or if you want to apply for advanced degree and a national interest waiver, wait until you get the advanced degree. So with employer sponsorship and with self-sponsorship, if you will initially be working during your OPT or your H-1B, you want to make sure that you still have valid status until you can get the self-sponsored visa or the employment visa, because some of these have like a wait, depending on the country you're from. And you want to always make sure that you have that. So some people will want to file when they're in their initial OPT, even if they're qualified for STEM OPT, just to make sure that they maintain status. Also, keep in mind that when you file for your green card and you file for employment authorization to be able to continue working for your employer until you get your green card, which can take some time, the work permit application might take time as well. So you want to make sure you still have time on your OPT or your H-1B to cover you until you can get the work authorization through the adjustment of status through the green card process. USCIS just updated their policy guidance in December of last year. So F1 students do need to have a foreign residence that they do not intend to abandon, but they can also be the beneficiary of a permanent labor certification application or an immigrant visa application, and you would still be able to demonstrate your intention to depart the US after a temporary stay in the US. Very important, because some people get concerned that they're on an F1, they still need to apply for their STEM OPT, and their employer wants to file for them. You can still do that. If a family or spouse files for you, you can still extend your OPT, because the OPT extension is much shorter than a regular adjustment of status EAD. So it might take up to a year to get an adjustment of status EAD, whereas it takes 90 days to get the OPT EAD. So you are, based on this change policy guidance, you're able to do both. Now, I'll stop here for questions. We have about 14 minutes.
Thank you so much, Patricia. One of the first questions we had was there were actually multiple pre-submitted questions that had a similar sort of idea behind them. And they were asking
Okay.
about the different types of visa programs and how they would be affected by current F1 status. And so can someone submit a green card application during their PhD program? Or similarly, can you apply for resident status even if you have a pending asylum case? How do they affect one another? Do they sometimes disqualify you from the other if you're in a current status, depending on your current
Okay,
status?
yeah, I addressed that early on because I talked about asylum first, so maybe they missed it. You are able to apply for asylum or have a pending asylum application and file for a green card through another means. Also, if you're still in school earning your PhD and an employer wants to file for you, you can do that, and you can still, at the end of your program, apply for an OPT EAD. Yes. So should I just continue reading the questions I didn't get to that were submitted in advance, Zach? Or do
If
you
you'd
have
like to, yeah, that would be great.
Okay. So the difference between the national interest waiver and the EB1 are that the national interest waiver, you have to show that your proposed endeavor has national merit and will benefit the US. You also have to demonstrate you're qualified to advance it, and that the government should waive the job offer requirement. With the EB1A, you're showing that you have extraordinary ability and you're demonstrating you meet 3 out of the 10 requirements. And it doesn't matter if you're a student in social science, finance, economics, you just have to meet the requirements. There are no special options for a green card for Canadians or Mexicans, but they do qualify for NAFTA-based temporary visas that can be renewed indefinitely. They're non-immigrant work visas. It used to be called a TN visa. And there are special requirements for Canadians and Mexicans. You do need an employer for those. So, there aren't more options to apply for permanent residency if you earn a PhD, but it makes it easier because you can then fit into, you get the assumption that, for one thing, with the national interest waiver, that you meet 2 out of the 3 requirements. And with a PhD, you might be able to go after teaching positions, which do not require labor certification. A PhD puts you in a better position when you're applying. And if you file for national interest waiver during your PhD program, it doesn't affect your F1 visa or renewal because USCIS changed their policy to state that you can have a pending immigrant visa application, which the national interest waiver is that, and still be able to prove that you have an unrelinquished, non-abandoned domicile abroad in your country of residence that you will return to. Now, the working for a nonprofit does not stop the OPT clock. Nothing stops it. Working for a nonprofit becomes advantageous if you're filing for an H-1B because nonprofits do not have a cap, a H-1B cap. So A, they don't need to play the H-1B lottery, and B, they can petition for workers any time of the year. They don't have to do it only during the H-1B lottery. And when should you apply for OPT? if you don't have a job by December, it's still recommended you file for OPT. You have up to 90 days. If you're STEM degree, you have up to 150 days. But if you get a job offer, you want to have the ability to work right away. And if you don't file for your OPT, then you won't have the ability to work right away. I know that some students choose to apply up to 60 days after they graduate for their OPT to start, up to 60 days after they graduate. So that may be an option if you don't have a job, but it's a risk because if you do get a job offer, you don't have your OPT, you won't be able to work right away. So those are the questions that I had, Zach. I don't know if any more has come in.
Yeah, there was one that came in today or during our chat specifically about physical therapy, and they asked that if it's not their current study right now when they're here at the university, but they were a physical therapist in their home country, can they use that degree from physical therapy from outside the US to apply for a green card under that option that you mentioned?
They would need to first get it evaluated for US equivalency, and then they would need to obtain whatever certification would be needed to work as a physical therapist.
Okay. Concerning the pathway related to harm or abuse, could you provide us some more examples of options that may qualify for that? Would being hit by a car in the US qualify, or would mistreatment from a supervisor count as grounds to file for that?
Okay, well, that question sort of merges different types of pathways.
Okay.
So the first pathway that involves abuse, neglect, or abandonment is for people who are less than 21 years old who have been abused, neglected, or abandoned by their parents. The next category would be the T visa, where someone has been forced to work without pay and they've been coerced or induced by fraud or by force to engage in this provision of services or labor without pay. The third category would be the U visa, where but the crime, there are certain crimes enumerated, and I'm not sure what being hit would qualify as. Is it a hit and run crime? Was it part of a domestic violence situation where a spouse or other family member ran the person over? So it just depends. More information would be needed in order to answer that question, but I've pretty much just covered the categories that involve abuse, so that the person who asks the question can get a better idea.
Thank you. I thought that was a great answer. And I guess I should also add that for some of these questions that are very specifically tailored to your circumstances as a student and your circumstances that are not going to apply to others, you can, through our office, meet with Patricia for a 30-minute free consultation. We contract with her once a month to provide these consultations. And so if you go to our website at gradlegalaid.umd.edu, which is probably where you registered for this workshop, you can put in a request to meet with Patricia and discuss what those personal details might have been to see if you would qualify for that, or some of the other questions that people have submitted that are very specific to your situation. This is sort of a more general question. How crucial is it to seek legal assistance for these different types of immigration pathways? Are there any that you think could be navigated on our own as a graduate student, or do all of them require legal assistance or legal representation?
No, you're never required to hire an attorney. If you read over the requirements and you feel that you're able to navigate it, then you would do it on your own. The benefits to hiring an attorney is that this is the area of the attorney's expertise. This is what they're trained to do. They know the law that surrounds it, and they know the type of evidence that would suffice. So it would end up being your comfort level.
If someone is currently in a PhD program, but already has a established record of publications with citations, is it possible to apply for the EB2 based on those publications before finishing the PhD program?
I think the student must mean the EB2 national interest waiver, and the answer would be yes. You can apply while you're doing your PhD if you already have a master's. If you do not have a master's, you have to wait until you actually have the PhD, which is an advanced degree. Remember, you have to be qualified on the day that you apply.
The next question touches back a little bit on our physical therapist question in sort of the field of health providers. Outside of physical therapy and professional nurses, are there other health providers that could qualify, like a prosthetists? Would they be eligible, or is it limited to the ones I mentioned?
They're limited to the two professions.
Okay.
The list changes as the US determines what jobs are in short supply nationally. The list changes. And just because someone who works with prosthetics is not listed on the list doesn't mean they cannot obtain labor certification for that position. Being on the list simply means that there's a shortage of these workers in all 50 states of the United States.
Okay. After filing for an EB1 green card application, can we, as a current F1 student, still leave the US and then re-enter? And is visa renewing still possible during this period?
Well, USCIS indicated that F1 students do need to have a foreign residence that they do not intend to abandon, but they can be the beneficiary of a permanent labor certification application or an immigrant visa petition, and may still be able to demonstrate their intention to depart after a temporary period. So this is USCIS's policy. When you're at the embassy, that's Department of State. It's a different agency. So they may have a problem with it. So it's different when you're in the US versus when you're before the Department of State. What I would recommend for someone in that position would be to show proof that you still have foreign ties, you still have your foreign residence, you do not intend to abandon. But it is a different agency. You know, the policy is only for USCIS. It is not for the Department of State, which is the people at the embassies.
Thank you. You mentioned certain countries having backlogs and delayed processing, and mentioned, I think I heard 6 years for some countries. Some of the questions are tied to generally how long do the processes take for the different visa applications? And are there any other factors that play into how quickly they can be processed?
Okay, so there are some countries that have a backlog. India and China usually do. Now, it is difficult to predict because it changes from month to month what the processing timeline is for each visa, but the EB1s have the least wait and the EB3s have the most wait. So if you're a priority worker. EB2 is in the middle, and it just depends on which country you're from. You know, depending on whether you'll have a backlog or not. And so it's a little difficult, but you would go to the visa bulletin. You can just do a Google search, visa bulletin, and it will tell you what the bulletin is, or, you know, for October. And if it says, for example, EB1, they're giving out, it might say it's current, or they could give you a date for when they're issuing visas. So if the visa they're issuing is for persons who filed a year ago, then you know the wait is a year.
Helpful. You mentioned when you were talking about family sponsorships, you said that we don't need a visa to file. Does that mean it's okay if my F1 visa is expired when I file?
If you are the spouse of a US citizen, you do not need to be in status to file. You can just file. And yes, if your F1 has expired, yes, you are able to, your spouse will file the petition for you, and you're able to file to adjust your status as long as you entered the US with a visa.
Can you tell us your thoughts on the diversity lottery?
Well, the diversity lottery works if you are already in status and in the US, or if you're outside the US and you know, you're applying from outside the US. But if you're here in the US, because you need to adjust your status in order to obtain the green card from the lottery, if you aren't maintaining status, you are unable to adjust status because it's not an immediate relative category.
Thank you. Okay, we'll do maybe two more. I know you said 1:35 was our target time. So for someone who's graduating in December and not in May without a job offer, should they still apply for OPT in December if they're, even though it's a December graduation with a OPT start date of January?
Well, they should. If you apply in December, I don't think you'll get your OPT with a start date in January because it takes about 90 days to get the EAD card. But as I stated during my presentation, if you find a job or you get a job offer, you don't have an EAD, you will not be able to work for that employer. So students have the option to apply for their OPT EAD 90 days before they graduate. So if you apply in December before you graduate, even if you put a start date of January, you will not get the card for about 90 days.
If I currently have a green card application, but my spouse just got US citizenship, do I still need to wait for my green card interview, or could I now be sponsored for US citizenship immediately through my spouse?
You cannot go from being a foreign student to being a citizen. You must first be a permanent resident before you can become a US citizen. If you obtain your green card through a US citizen spouse, you qualify to become a US citizen after 3 years, and you need to show you're still married to that spouse. Now, your spouse just became a US citizen. If your spouse has not filed yet for you, your spouse can file for you and you would be an immediate relative. This would be advantageous over your spouse filing for you while the spouse is still a permanent resident.
Let's try to fit it. You were so efficient. Let's try to do one more real quick.
Okay.
One was a pending asylum application, but they were asked by their advisor to do a 2-week research project out of the country that's not in their country they're applying for asylum under. Is that going to cause them problems if they traveled and then tried to re-enter?
Yes, if you have filed for asylum and you leave, your application will be considered abandoned. It doesn't matter that you're not going to the country. When you're an asylum applicant, you're allowed to travel if you have an emergency. I don't know whether the professor asking you to travel for school or work as a student would qualify as an emergency. You would have to apply for what is called advanced parole. And if it is granted, then you will be able to travel and come back.
Wonderful. Thank you so much, Patricia. This, as always, is such a wealth of information that is helpful for me to learn, but I know even more helpful for the many students that the 75 students who watch this live, and probably the hundreds more that will watch this recording. We really appreciate everything you do for us and the time that you volunteer for our office. And for any of the students who are still around, you can always catch up with us at gradlegalaid.umd.edu. Click the workshops tab. You can see a recording of this. You can also see the recordings of Patricia's other workshops that I dropped the link in the chat for the specific one about national interest waivers that she did about 1.5 years ago for us. And so we're here to help you with whatever your issues are, legal or visa-based, as much as we can. So visit our website, reach out to us, let us know how we can help. And we thank you for attending, and we thank Patricia for her time as always. Thank you so
Always a
much, everyone.
pleasure. Okay, thank you, Zach.
Thank you.